After 3 years of investigating Thesis-Gate, Birkbeck University revealed to us that examiner names and viva dates and locations are not private information. It proves that the University of London and the UK Information Commissioner's Office has been covering for Tsai Ing-wen. Tsai Ing-wen's thesis never existed. Education Ministry files have attested to such. Professor He Defun has created an extensive documentary detailing just how deep Thesis-Gate goes. Taiwan's presidential office continues to ignore Thesis-Gate's glaring issues. It doesn't even dare to advance its court cases against the 3 scholars. It's clear the presidential office doesn't plan on doing anything about Thesis-Gate. However, the more pressing issue is, why doesn't the University of London dare expose Tsai Ing-wen? From the files published on whatdotheyknow.com, we can see that someone at the school helped facilitate an entry into the ProQuest database on Tsai Ing-wen's behalf. That ProQuest entry does not stand up to scrutiny. It does not contain the thesis's microfilm or abstract. It is nothing but an empty shell. What's more is that the thesis is filed under psychology and statistics in the database. LSE Law School refuses to comment on who helped enter the thesis into ProQuest. In June 2011, after Tsai Ing-wen's group attempted to smuggle a thesis into the library, someone launched an effort to find Tsai's thesis at the schools. That search effort ended with someone saying that school archives held Tsai's files in email exchanges. These emails provided the illusion that 3 copies of Tsai's thesis once existed. If this information is simply an internal school review, then we might be able to say that someone just has faulty information. Nobody has done anything illegal. In 2015, the University of London passed the buck to a now defunct higher degree office. It said that the transcript office no longer had Tsai's records, but that the higher degree office would have held them. However, the school boldly said that it could confirm an award date for Tsai Ing-wen's Ph.D. At that point, the University of London became complicit in this scandal. Furthermore, the school helped get Tsai's thesis into the British Library, which in turn was information the presidential office used to refute accusations.
这本论文在35-36年前就已经存在，有2个证据。第一个，大家在过往的时间里面就已经知道，从大英图书馆的论文检索系统里面就已经可以查得到蔡英文总统这一本论文的相关记录，这是第一个证明。
In 2019, LSE once again helped Tsai Ing-wen by accepting a faxed thesis into their women's library collection. This is the infamous black leather thesis, which was placed under strict viewing restrictions. That same year, the school published a statement saying Tsai's degree and thesis are real, but the thesis was simply lost.
这个论文当年是35年前的论文所以当时的做法有它的做法嘛那如果你以现在的眼光去看过去的，那当然就说你或许有一些要问的问题，但是基本上我们都处理论文都按照当时的规定在处理的了那我想现在有很多人也都没有否认有论文这件事情嘛，不是吗
？In 2020, University of London data manager Kate Good falsely told the ICO that the school had Tsai's Viva report. He also said that the school once had a copy of Tsai's thesis, but it was lost due to library restructuring over the years. Good's testimony to the ICO sparked renewed interest in Tsai's Viva report, but that turned out to be a dud. The school had no such thing. There's no way Thesis-Gate could have gotten this far without the school's help. The University of London will be remembered for its part in this scandal. A turning point for Thesis-Gate was when investigators decided to take their grievances to the UK's tribunal court. The offending group never imagined this would happen. On November 26, 2021, LSE admitted it did not have Tsai's Viva report. In February 2022, the University of London's new data manager said the school had no information on Tsai's examiners or Viva dates. The original data manager who gave false information, Kit Good, resigned from his post in September 2021. Information Commissioner Elizabeth Denham also resigned in November of that year as well. This simple matter of academic dishonesty has now become an international political scandal. Tsai Ing-wen will not only destroy her own legacy, but she will also take Taiwan's justice system and the University of London's reputation with her. Tsai Ing-wen's scandal is like a virus, corrupting justice and social values wherever it goes. Besides the University of London, the UK Information Commissioner's Office is also protecting Tsai. The ICO is not acting in the public's interest as it should be. Instead, it has become another cog in the political machine, helping to conceal the truth. Let's say that the ICO's June 11, 2020 ruling was solely based on the University of London's testimony and that the ICO isn't covering for Tsai. We'd be conspiracy theorists at this point, but how do we know the ICO is involved? Last episode, we talked about how we requested an internal review from the ICO. We asked 3 questions in relation to the June 11, 2020 ruling. Number 1, please disclose any meeting minutes, including web conference recordings, email correspondence, text reports related to the ICO ex-commissioners reaching the wrong conclusion in the decision notice. 2. Has the ex-commissioner or case investigator ever asked the University of London Library to provide a record of this entry of this thesis in dispute? If not, why? 3. How do ex-commissioner agree the original copy held by the university library was lost or misshelved sometime between mid-1980s and 2010s, over which period there were numerous structural changes to the library? Who provided the false information and time frame, 1980s to 2010s, regarding this misshelved information? The ICO responded to our questions on whatdotheyknow.com, but not without first calling them vexatious. The ICO simply froze the original applicant's account and left it at that. Our questions were asking for clarification as to why we should believe the ICO and the University of London. We wanted to know if the 2 entities had contact or discussed the matter, or if any evidence was presented. But the ICO decided to give a very politically motivated answer. This request is one of a number of requests the ICO has received about this topic and recognizes that they form part of a concerted campaign per Section 14 of the Freedom of Information Act. Tsai Ing-wen may have been the implicit topic of the 3 questions, but the questions were in fact asking how it came to the conclusion it did. In the past, so much as typing Tsai Ing-wen into whatdotheyknow.com would lead to an account ban. However, we did not mention Tsai. We just wanted to know more about the decision mechanisms, and yet the ICO added Tsai Ing-wen for us and left it at that. The ICO is also very upfront, acknowledging the reason for not answering our question is because the key question to be asked is whether the request is likely to cause a disproportionate or unjustified level of disruption, irritation, or distress. Just like how it dispatched Michael Richardson's claims by suggesting that revealing Tsai's information would result in damage and distress to her, the ICO here claims that the information we're asking for this time around is likely to cause a disproportionate or unjustified level of disruption, irritation, or distress. The ICO doesn't care about right and wrong or justice. It cares about disruption, irritation, and distress. The ICO then completely ignores the question asked and simply goes off about why it believes Tsai and the University of London. The ICO says that when handling such cases, its purview is limited when it comes to personal data of third parties. We talked about this in our last episode. The ICO is particularly good about hiding Tsai's information behind private information regulations, including her Viva examiner and date. However, we already know from the Si Wei-Chuan case that that explanation is a lie. We obtained Si's examiner and Viva information without trouble. The ICO is now simply protecting Tsai. That's why it's hiding behind this third-party explanation. If Tsai weren't president, would the ICO still grant her such preferential treatment? In reality, Viva dates and examiners are public information. This is particularly true for government-funded universities. Such information should be accessible to anyone under the Freedom of Information Act. Our three questions to the ICO were simply looking for clarification and transparency. Instead, the ICO came back and accused us of prying into personal information. The ICO is the one jumping to these conclusions, so who exactly is being vexatious here? Next, the ICO said that the University of London already provided enough information in the June 11, 2020 ruling. The ICO asserted that the university provided credible information and that the matter was dismissed in the first-tier tribunal. The ICO then included a final warning. It is said our intent was to try to add weight to theories around the falsification of President Tsai's Ph.D., which have already been considered at length by the Commissioner and the Tribunal and found to be entirely lacking in substance, as well as to express dissatisfaction with the Commissioner's decision in these matters and cause deliberate disruption to the ICO's services. Neither is it correct for the ICO's information access services to be seen as a channel through which to try to obtain information about other public authorities, having thoroughly exhausted both the correct procedures to obtain information from the relevant authorities and the appropriate means for pursuing dissatisfaction with the outcomes. The ICO further closed out by saying, "It is not within the public interest for the ICO to further expend its finite resources in responding to requests of this nature when it is clear that doing so will not put to rest the postulated theories, given the unwillingness of their proponents to accept the clearly explained and well-evidenced position of the ICO, the University of London, the London School of Economics, and the First-Tier Tribunal on the matter thus far." This ICO ruling did nothing to address the ICO's mistakes. The ICO just wants to keep towing the line, even though Kit Good's testimony has already been proven false. This is how the ICO operates. It keeps hammering the same tired points home. It uses rulings made on bad information to respond to our inquiries. Even though we've proven that those rulings were based on bad information, the ICO doesn't care. According to the ICO, as long as we challenge them, we are disrupting their services. However, there is no reason to worry. Originally, investigators wanted the University of London to come clean about its collusion with Tsai. However, from those efforts, at least, we are now sure that the university is an accomplice. Knowing exactly who your opponent is isn't a bad thing. Now that we have confirmed that the ICO has chosen to stand with the wrongdoers, we know they will only stand in our way. We now know that we only have to keep drilling the ICO. Sooner or later, someone in there will say something wrong and it will all come crashing down. Dr. Huan Si-lin published a joint statement in February alleging the London University's involvement in playing cover-up for Tsai Ing-wen. He sent the statement to University of London Vice-Chancellor Wendy Thompson, LSE Director Baroness Minosh Shafiq, and of course the ICO. Naturally, we had a lawyer at the ready to follow up with the institutions. Any hope we harbored that the ICO will come forward and admit its mistakes has dissipated. However, the ICO has proven helpful. Through them, we learned on November 26, 2021, that LSE does not have Tsai's Viva records. That was instrumental in moving the investigation forward. The ICO also gave us the file dump from the University of London, which proved the school was helping Tsai's cover-up. The ICO can't respond to questions about Tsai Ing-wen head-on. When the ICO couldn't offer any more insight in response to our inquiries, we turned elsewhere. On April 19th, a high-ranking information officer, Joanne Wright, responded to us. Wright said up front that she had not handled this case before, but she also said that she agreed with the ICO's decision up until that point. The interesting thing is, Wright said that if we were unhappy with her decision, the applicant could appeal to the ICO. That's interesting. If we're unhappy with the ICO's decision, then we have to appeal to the ICO. Won't this have us running in circles? If we're unhappy with an ICO ruling, then the next step should be to go to the tribunal. Yet the ICO doesn't tell us that and wants us to appeal to itself? Is the ICO telling us this because it's afraid of this case going to tribunal? Is the ICO worried that we'll unravel its June 11, 2020 ruling? You'll remember that Michael Richardson took the ICO to tribunal once. The ICO dragged its feet, making the issue not about the matter at hand. Instead, the ICO wanted to talk about nationality while stalling to give its plea report. The ICO went so far as to tell the tribunal that it was the only authority in the UK that could decide what information could be disclosed. It's clear the ICO is afraid of the tribunal. The only reason why LSE admitted it didn't have Tsai Ing-wen's Viva report is because we were once again about to take the ICO to tribunal. When investigators take the ICO to tribunal, anything can happen. In one case, the judge agreed that it was unlikely that Tsai's thesis disappeared. However, in the end, the tribunal ruled with the ICO, saying the University of London didn't have to reveal Tsai's examiners. In another case, the tribunal outright accepted the ICO's ruling and sided with it. Investigators are 0-2 when it comes to tribunal cases. However, when Richardson said he wanted to appeal his tribunal case, opponents in Taiwan got nervous. During that time, a lot of misinformation started circulating on Taiwan's internet. The goal of that false information was to weaken Richardson's resolve to appeal. However, things are going ahead as planned. The success of Shi Wei-Tren's Viva inquiry gave our case in tribunal all new direction. This is all thanks to our meticulous investigators. On April 25, 2022, something shocking came to our attention. American independent journalist Michael Richardson was notified that the UK's administrative courts have looked at his appeal, and his case has drawn Judge Mark West. The courts told Richardson that it scheduled an online hour-long pretrial hearing for the case. Richardson's case focuses on revealing Tsai's examiners. Mark West graduated from Cambridge University and is a seasoned lawyer. Having him handle the case is sure to rattle Taiwan's presidential office. This trial will be different from the one in the first-tier tribunal. We have much evidence to counter the ICO's claims. Newly unearthed evidence will bring this scandal to light. This includes the LSE's counsel's claim that it denied holding Tsai Ing-wen's Viva reports on November 26, 2021. Tribunal Judge Hazel Oliver said on December 18, 2021 that they believe the school's explanation that Tsai's thesis was lost is untrue. Susie Merriweather denied that the University of London had information on Tsai Ing-wen on January 11, 2022, which is contrary to what Kit Good claimed. And finally, the successful Freedom of Information Act request that saw Shi Wei-Chun's examiners and Viva date revealed on April 10, 2022. We will hold our heads high as we go into this pretrial hearing. The offenders are the ones that should have reason to worry. Remember, in their panic, the wrongdoers had LSE's Kevin Haynes throw out Michael Elliott and Leonard H. Lee's names as Tsai's examiners. Those two couldn't have overseen Tsai's Viva. Then Tsai's lawyer Lien Yuanlong changed Tsai's Viva date to October 17, 1983, and added a third examiner name, Richard Dale. We don't need experts, we need calm and reasonable minds. If Tsai's Viva really did take place, then LSE and the University of London would have told us who her examiners were long ago. Why is something so simple a matter of personal information? Furthermore, even if it is personal information, why won't Tsai Ing-wen authorize the information's publication? It seems that Thesis-Gate has taken a backseat to the war in Ukraine and the pandemic in 2022. However, that doesn't mean we're not making moves. There are two more tribunal cases that are slowly making progress. This upcoming pretrial hearing is just one breakthrough of many to come. Many investigators are worried that the UK courts will also make this about politics. Mark West might hand us an unfavorable outcome. However, so long as we don't give up, the other side can never win. The tribunal is not our investigators' only course of action. As the UK prepares to roll back its lockdown restrictions, our investigative team is ready to make its next move. Coincidentally, while the UK tribunal brews, courts in Taiwan have been putting on a witch hunt for Dr. Dennis Peng. After investigators lost Richardson's first tribunal case, Taiwan's courts went quiet, almost as if they didn't see a need to give Dr. Peng a hard time. Now, as court proceedings in the UK start up again, Dr. Peng's case against Judge Zhang Yonghui was suddenly issued a court date of June 11, 2022. The subpoena for that case says that both sides must provide a plea within 20 days. It also said that Dr. Peng had to show up to court, otherwise the court would give a default judgment. Defendant Zhang Yonghui seems ready, if not eager, to meet in court for a round of debate. Aside from the University of London's latest statements, if Judge Zhang familiarized herself with the email chains published on whatdotheyknow.com, she'd know Tsai's thesis doesn't exist. Anything about Tsai's thesis and where it is now comes from pure speculation and hearsay. The only people who can attest to a true thesis would be Tsai's examiners. However, we all know what Tsai is getting at. Her propaganda machine is losing steam. The truth is in London, while the revolution will be in Taiwan. This is the darkness before the dawn. Let us all look forward to the future.